Hey everybody, and welcome back to the Law Unscripted. Today we are doing a lecture on contracts, and this is lecture number 2. So let's talk about discharge and breach. All right, discharge. A contract is considered discharged if the agreement has been completed or fulfilled by both parties. It's done. You both did it. You got the benefit of the bargain on both sides. You can walk away pleased that your contract worked and you got exactly what you wanted from it. Okay, so there are different ways to complete a contract, and not all of them are breach of contract, right? Most of them are normal discharge. There is accord and satisfaction. In the world of contracts, accord and satisfaction is actually the acceptance of substitute products, okay? In other places, the world of criminal law, the world of civil law, accord and satisfaction is when you actually complete payments, okay? So if I have a judgment against an insurance company to pay, I'm a personal injury attorney mostly, and if I've gone to court and I get a judgment against an insurance company to pay my plaintiff $30,000, then they got to cough it up. And when they do, we write out this document called an accord and satisfaction, and we send it to the court. And we tell the court and indicate to them that the judgment has been fully paid and the parties are releasing each other from the entire lawsuit. So the lawsuit was satisfied, the parties walk away, they don't have to do anything more because it's accord and satisfaction. This is also used in criminal law. Usually with restitution. I have some clients who have had destruction of property, okay? It's sometimes a misdemeanor, sometimes a felony, depending on the price and the value of the property that was damaged. Well, you can enter an accord and satisfaction where the charge would be released and dismissed rather than fully prosecuted and a conviction be had if the defendant can repay the party for the damage and make that party whole again, whether providing a different good, an exchange of it, or money for the good that was destroyed in this conversion, in this destruction. So that's the difference of all of the accord and satisfaction. So let's talk about it with contracts. We're going to go back to my pecans. The seller contacts me and says, you know what, we don't have pecans this week. We couldn't get them anywhere. We don't have them. We can't send them to you. What do you want us to do? Oh, we have almonds. We'll offer you the almonds. Can we substitute the almonds for the pecans? Okay, normally in my old store, I would have had to say, I can't, because the cookies don't call for almonds. The cookies specifically require pecans. That's the recipe. So that's not good. You're just going to have to cancel for that week, and you're going to have to pay me what I would have lost or what I am losing because I cannot sell those particular cookies. So I'm losing profit, losing, some value for the goods that I would have had with the pecans. But if I agree to the almonds, it's a substitute contract. It's a new contract. It's an accord and satisfaction where I agree, okay, you don't have pecans, I don't need the pecans, or I would have liked to have the pecans, but we're gonna try the almonds and see what happens. This is new consideration. You're going to pay a different price. The contract itself, the overall contract for this installment contract, wouldn't necessarily be, changed completely just that week. And you agree to the substitute goods.